Jersey says, well, we have to look at the subcontractor exception within the your work exclusion. And what they did is note that the change that was made in 1986 to the your work exclusion, adding the subcontractor exception, restoring coverage for faulty workmanship of subcontractor. This didn't happen in a vacuum. As we started out in our building blocks, ISO drafts these forms. Well, what happened in the industry is that policyholders wanted this type of coverage. There was a desire out there in the business community predominantly by contractors, general contractors. I want coverage for faulty workmanship of my subcontractor. I can be responsible for myself and my work product, but I don't want to be responsible, completely responsible for the subcontractor's work. What happens if the subcontractor does some work when I'm not there? What if the subcontractor negligently applies the stucco, doesn't put enough sand in the mix or water, and it later leaks? So there was a desire in the business community, in the contractors community, to have coverage for faulty workmanship of subcontractors. That was strongly expressed. And the market, the insurers, saw it as an attractive vehicle that, yes, maybe if we provide this coverage for faulty workmanship of subcontractors to a general contractor or a contractor that they're working for, that we can sell more of the policies and would be an attractive product. So the Florida Supreme Court, the New Jersey Supreme Court, they're looking at this. And they have, under the rule of construction, they're also taking into account, look, we need to read the policy as a whole. All the provisions in the policy need to make sense together, working together, read together. We can't read anything in an isolated way, and no term or provision can be meaningless. So they looked at it and they kept coming back to this subcontractor exception within the your work exclusion. And lo and behold, they even went back to ISO, and ISO had a 1986, it had a circular in July of 1986 that explained that, in fact, yes, that was what the change in the policy, the drafting of the policy, the 1986 form, CGL form, that's what was intended. It was intended to cover damage caused by faulty workmanship to other parts of the work in progress, or damage to or caused by a subcontractor's work after the insured's operations are completed. So damage to, if we're talking about completed operations hazard here, my condominium building 30 stories high is already completed and we're starting to have water damage. The subcontractor was the roofer that laid down the roof. And we're having water leaks and water damage inside the condominium building. The ISO circular explained that that type of damage caused by the subcontractor's faulty workmanship was covered under the 1986 policy. That exception within the your work exclusion restored coverage that was provided under the CGL insuring agreement.